The Laundries have filed a motion to dismiss the lawsuit the Petitos filed against them for emotional distress for damages around the death of their daughter, Gabby Petito. So we're going to look at why. Why are the Laundries asking the court to dismiss the Petitos lawsuit? What are their grounds? Will they succeed? What will be the outcome? Let's take a look at the actual motion to dismiss. You know me, I like to look at the actual court document. Okay, so who am I? I'm Michele Hagan. I'm a legal analyst and a former prosecutor, also a former domestic violence prosecutor. And you may recognize me because I've provided a lot of coverage on the Elizabeth Holmes trial and a bunch of videos I've already done on the lawsuit. You might want to take a look at that, examining the the Petito versus Laundrie lawsuit, and several other videos to get yourself up to speed. So in case you just popped onto this channel, Gabby Petito was murdered by her boyfriend, Brian Laundrie. Brian Laundrie's parents, Christopher Laundrie and Roberta Laundrie, are being sued by Gabby Petito's parents, Joseph Petito and Nichole Schmidt. They are being sued for emotional distress because Gabby's parents allege that Brian's parents did not give them the information about Gabby's whereabouts, what happened to Gabby, where Brian was, etc. So we're going to look at that lawsuit. Thank you very much for subscribing. To all you subscribers, thank you so much for supporting my work. Please do subscribe if you haven't. And also, please do leave a comment or question and hit the like button, share these videos, and do subscribe. Oh yeah, hit the notification bell as well. All right. So let me just give you a little background before we look at the lawsuit. So this is a civil case. This is a civil case. Gabby's parents are seeking damages for the emotional distress they claim, they allege, that was caused by Brian's parents withholding information, not disclosing information regarding what happened to Gabby Petito. And again, this is a very, very, very tragic circumstance for both families, okay? They both lost their kids, all right? So I'm not here to condemn or accuse anybody. But anyway, so on a couple weeks ago, Brian's parents were served with the lawsuit, and they have 20 days to respond to it, right? So what they have filed, they have a counsel, new attorney, not Steve Bertolino. There's another attorney, and we'll look at that in a second, who's representing the Laundries, and he filed a motion to dismiss, right? They need to file a motion before they answer the complaint. In other words, before they give all their defenses, they have to challenge it first. You know, is the allegations in the lawsuit, is the pleading sufficient? Okay, and I know this gets all into legalese, but basically, what a motion to defense is to ask the court to throw the lawsuit out because either it doesn't state a cause of action, meaning everything that they say in the lawsuit doesn't amount to negligence or causing emotional distress, or in this case, I think they're alleging intentional emotional distress by Brian's parents. Or they could say that maybe whatever's in the lawsuit, they didn't state enough facts to support those claims. Okay, so hang in there. It's a 20-page motion to dismiss, but I'm just going to highlight the areas that I think are important, and then I'll do a wrap-up at the end, okay? So please do subscribe and please do comment, because this video is simply my opinion, just for educational, informational purposes only. I'm not a Florida lawyer. I'm a California lawyer, so I'm going to tell you in reference to my understanding of California law too, but also we're just going to, as far as the procedure, but we're going to look at the lawsuit, okay? So please do leave your analysis. What's your take on this? All right. So let's take a look at the complaint here. I should call the motion, not the complaint, the motion to dismiss. This was their response to being served with the lawsuit by Gabby's parents. Okay, so this is the actual court filing. It says right up here, filed on March 30th at 4:01 p.m. Joseph Petito and Nichole Schmidt, those are Gabby's parents. The plaintiffs are suing Christopher and Roberta Laundrie, Brian's parents. All right, so this is the Laundrie's response. It's a motion to dismiss. They want to dismiss. They want to throw out the lawsuit. And in this motion, they state the reasons why the court could throw out the lawsuit filed by Gabby's parents. So it says defendant's motion to dismiss complaint. The defendants, Brian's parents, move to dismiss the complaint. For failing, the reason why is because they're saying the complaint fails to state a cause of action for intentional infliction of emotional distress. So whenever you file a lawsuit, you have to lay out the elements, what the law requires to show, in this case, intentional infliction of emotional distress. Plus, you need to, in that lawsuit, indicate the facts that support it. So here they're saying it's failing to state a cause of action. There are no facts that could support this cause of action, and the court should dismiss the complaint with prejudice. So they're saying that the lawsuit that they were served with, there are no facts in that lawsuit to support a cause of action. And we'll get into why. But they're asking the court, can you please, they didn't say please, I did. Can the court should dismiss the complaint with prejudice? What does it mean, dismissing it with prejudice? Prejudice means that they're asking the court to not allow Gabby's parents to amend, to fix their lawsuit, to fix the pleading. They're asking the court to go ahead and just dismiss it so they can't file it again, right? Dismiss it with prejudice. So what they indicate here is the background, and let me scroll up here so you can go ahead and read this. These are the facts surrounding, you can read it. Mainly they're alleging that Brian's parents knew, they were advised by Brian that Brian had killed Gabby. One of the other main points that they're alleging is that Brian's parents made arrangements or were making arrangements to get Brian out of the country. So, and they didn't disclose, they're alleging they didn't disclose information to Gabby's parents about what happened to Gabby. So you can go ahead and read this. So they're saying the complaint should be dismissed with prejudice. They should not be granted a leave to amend. That means the court could say, I'll dismiss this complaint, this lawsuit, and I'll give you an opportunity to go and fix it, basically amend it, put in the facts that support it, clean it up, make it such that it's legally sufficient. So they're saying, Brian's parents are saying, don't give the plaintiffs, don't give the Petitos, Gabby's parents, a right to fix this complaint. Just dismiss it outright with prejudice, meaning they can't file it again, right? So, and they're saying even if they amended it, even if they fixed the lawsuit, it would be futile because it's insufficient as a matter of law. In other words, assuming everything in that allegation, in that lawsuit, everything that they allege is true, it doesn't amount to negligence or intentional infliction of emotional distress. It cannot amount to it, and we'll get into the reasons why. They're talking about the complaint is insufficient and deficient as a matter of law for many reasons, and those deficiencies cannot be cured by amending the complaint, by fixing it, putting in the facts to support each of those allegations. The gravamen of the claimed wrongdoing is that the Laundries exercised their constitutional rights and essentially made no mistake. So what they're saying is this lawsuit is about the Laundries. The Laundries had a right to exercise their constitutional rights, to remain silent, right? They don't have to talk. That's what they're alleging in this. That's what they're stating in this motion to dismiss. And then they say, as a matter of law, the Laundries' silence, their conduct, could not form the basis of a claim for intentional emotional distress. And why is that? The Laundries' silence could not form a basis of a claim for intentional infliction. So what the Laundries did does not amount to intentional infliction of emotional distress. That is what the Laundries are saying. The Laundries' constitutional rights and the elements necessary for such a cause of action would not change with an amendment. So what they're saying is, Judge, they can't amend this complaint because the Laundries had a constitutional right. It won't amount to intentional infliction. In other words, there's nothing they could do to fix this complaint because what they're being sued for does not amount to intentional infliction of emotional distress. In other words, the Laundries being silent does not amount to intentional infliction of emotional distress. I think that's what they're saying. You let me know, but again, this is just my opinion. There are no more facts that could allege that would bolster the plaintiff's claim. In other words, there's nothing that they could add to that complaint because it's already been resolved. I mean, again, this is a terrible, terrible tragedy that these parents lost their children. The plaintiff's failure to state a cause of action in the complaint provides ample basis to conclude that the plaintiffs would not be able to add missing but required information if they had an opportunity to bolster their allegations. So in other words, Judge, don't bother. Don't bother allowing them to amend because there's no new facts that they could even allege. There's nothing more that they could add to that complaint. Okay, let's look at why. So they're saying the pleadings are deficient, and they point out, I think, 6 reasons why. All right, we'll get into the Constitution. We'll talk about Florida's Constitution. We're going to get there. Okay, so the reason the pleadings are deficient is because they're saying the complaint's ambiguity and lack of separate statements and counts as each plaintiff and defendant independently warrants dismissal. So in other words, if you look at, and you need to go, if you haven't, you might want to, go look at the video I did on examining the Petito versus Laundrie lawsuit, because I walk you through all the allegations, and you can go ahead and look at that lawsuit. But what the Laundries are claiming here is that there's too much ambiguity. There's too much ambiguity in that lawsuit, in the complaint. And it doesn't specify who did what. Therefore, the court needs to dismiss it. It says the allegations must be sufficient to inform the defendant of the nature of the cause against them. In other words, you can't just do blanket allegations. You need to let us know, what did Roberta Laundrie do? What are you alleging Roberta Laundrie did or didn't do? What are you alleging Christopher Laundrie did or did not do? All right, it wasn't specific enough to give the Laundries notice, to know exactly what they're being sued for and who's being sued for what. Then they say the defendants assume the cause of action. They're assuming it's intentional infliction of emotional distress. And again, if you go look at the 2 videos I did examining the lawsuit and then clarifying the next steps video that I did, you will see that even I was looking at this going, okay, I assume when they use those words like outrageous, that means this is intentional emotional distress, because it wasn't really clear what they were being sued for. All right, so what the Laundries counsel is saying is that the defendants assume the cause of action is one for intentional infliction of emotional distress because words relevant to the elements of that cause appear in the complaint. They're not using, in the complaint it doesn't say you are being sued for intentional infliction of emotional distress. It uses words that could be seen as claiming that. And they say, however, the phrase intentional infliction of emotional distress appears nowhere in the complaint. It's also possible, like, check this out. It's also possible that the plaintiff, Gabby's parents, might be trying to allege a cause of action for tortuous, what a word that is, torturous interference with a dead body. So in other words, the Laundries are confused. Are you claiming intentional emotional distress, infliction of emotional distress, or are you claiming that we were allegedly torturous interference with a dead body? Because of the words that are in the complaint, the Laundries are confused, okay? And even it says here, if you look at footnotes, you always want to read them, invoking the terms malice or great indifference to the rights. And they use those words in the lawsuit. Again, go look at the examining the lawsuit video, and you will see where I walk you through it. And they use the words malice. And those words relate to interference with the dead body, not with intentional infliction of emotional distress. So again, that goes to the complaint is ambiguous, right? It needs to be really clear when you file a lawsuit. Okay, I'll just scroll through this. The complaint is so vague, it's subject to dismissal. Okay, you can go ahead and read through this. It's deficient because it names two plaintiffs without attempting to distinguish between them, who did what. You can go ahead and read this. And then they say, while these two pleadings deficiencies require dismissal and could potentially be corrected by amendment, potentially be corrected if they're given another shot to fix up the complaint, the words that they use, the plaintiff's legal theories are fatally flawed and could never be remedied. And here's where we're going to find out why the lawsuit filed by Gabby's parents could never be remedied. I'll give you a clue. The Constitution. That's what they're going to claim. Not only the U.S. Constitution, but the Florida Constitution. Okay, so then they say the complaint fails to meet factual pleadings. So in other words, they don't put enough facts in the complaint to back up to support this intentional infliction of emotional distress. And they say Florida is a fact pleading, not a legal conclusion, not what my opinion is, but it's a fact, meaning you need to put the facts in the complaint. To withstand dismissal, a plaintiff must, not may, must allege more than a naked legal conclusion. It's insufficient to plead opinions, theories, legal conclusions, or argument, right? You need to state the facts in the pleading, in the lawsuit, in the complaint. Okay, so you can go ahead and read this. Then they talk about Florida does recognize intentional infliction of emotional distress as a tort, civil tort, right? They're seeking money damages. To state, and here are the four elements of intentional infliction of emotional distress. Each one of these elements, you're going to sue somebody for intentional infliction of emotional distress in a lawsuit, in the complaint. Each one of these elements needs to appear in the complaint, and the facts that support each one of these elements needs to be in the complaint. Otherwise, the defendant, in this case, the Laundries, bring a motion to dismiss. Okay? So what are the four elements required for intentional infliction of emotional distress? 1, deliberate or reckless infliction of mental suffering. 2, outrageous conduct. 3, conduct caused the emotional distress. Number 4, the distress was severe. So in other words, they're inflicting mental suffering. It's outrageous. Their conduct was outrageous. The conduct caused emotional distress. In other words, their silence, they're not withholding information, caused the emotional distress that Gabby's parents suffered, and the distress was severe. All right, so all of that, and the facts that support it need to be in the complaint, in the lawsuit. And you can go ahead and read this. It's so outrageous in character, it's beyond all possible bounds of decency. In the court, and it's an objective test. It's not subjectively what the Gabby's parents suffered. It's what objectively the court has to evaluate the conduct as objectively as possible to determine whether or not it's atrocious and utterly intolerable in a civilized community. And believe me, I get it. You know, when you're looking for your child, you're begging for their help. I mean, these are tragic circumstances. And I know the outrage of people. Believe me, I know the outrage. So they're saying even if the complaint alleges facts, those facts, if true, must establish a cause of action. And even though they allege those facts, they're saying even if everything in that complaint is true and it is proved, that still doesn't establish a claim, a cause of action for intentional infliction of emotional distress because, and here it is, the Laundries' actions were legally permissible, constitutionally protected, not outrageous, and did not give rise to any cause of action. The Constitution. Okay? Then they say that the Laundries' inaction was not outrageous, but was legally permissible and constitutionally protected. All right, you can go ahead and read this about outrageous conduct. And then it says it's not enough that the defendant acted with the intent, which is torturous or even criminal, or that the defendant intended to inflict, or even that the defendant's conduct was characterized by malice. It's not enough. Rather, liability is established only when the alleged conduct is so outrageous in character. Yeah, you could say, withholding information when you're looking for your daughter, that's outrageous. You could definitely argue that. But the Constitution. How are you going to get past the Constitution? Basically is what they're going to allege here, what they're going to state. Okay, this is talking about you can't just plead conclusions, you have to state the facts. Go ahead and read through this. These are all the facts regarding what events occurred. Whether they were making arrangements to help Brian leave the country, what they knew was, did Brian advise them that he killed Gabby? And they say, the Laundries say, none of the allegations that are stated in the complaint describe outrageous conduct. None of it. And we're going to get to why. They failed to make any contact. Is that outrageous? And they're saying it's a high standard to show outrageous conduct. And they say the Laundries' decision to exercise their constitutional rights to silence, privacy, and counsel could not be further from conduct that is extreme. In other words, the Laundries' decision to exercise the constitutional right of silence, to remain silent, privacy, and to retain counsel does not amount to outrageous conduct. Why? Because it is what most people would and should do in a situation and in a civilized community. The letter by the plaintiffs, by Gabby's parents' attorney, even acknowledges the complicated conditions faced by the Laundries. They said in the letter, we understand you're going through a difficult time and your instinct is to protect your son is strong. I mean, parents, we protect our children, okay? I know this is difficult, but, this is very, very tragic circumstances and it's very unfortunate. Very unfortunate. We understand you're going through a difficult time. To protect your son is strong. The plaintiffs cannot express sympathy and understanding, blah, blah, blah. If the Laundries' act of doing nothing, remaining silent, doing nothing other than maintaining their privacy and silence, is enough to subject them to a supposed cause of action for intentional infliction of emotional distress, then there would be virtually no limitation on the tort of intentional infliction of emotional distress, and the fundamental right, the constitutional right to remain silent. What amendment? What amendment? The Fifth Amendment. Remain silent under any circumstances would be obliterated. Labeling their silence as outrageous is particularly incongruous. You can read this. The complaint says nothing about whether the Laundries actually received the letter where the Petitos were reaching out. Please, we beg you to tell us. There's nothing to show the Laundries actually received that. It's not outrageous conduct to remain silent. You can go ahead and read this. Even malice and indifference is not enough for intentional infliction of emotional distress. And to permit this lawsuit, to permit this claim to move forward, would trample the Laundries' constitutional rights. They're entitled to exercise their legal rights. You can go ahead and read this. And if the conduct's privileged, the actor is never liable. That's what the case law says. The conduct is privileged, meaning constitutionally protected. The right to remain silent. They asserted their rights. That's what they're saying in this motion to dismiss. The Laundries had a legal right to do or not do. They're entitled to the right of freedom of thought protected by the First Amendment, which includes both the right to speak freely and the right to refrain from speaking at all. That's the First Amendment. And because there was a criminal investigation going on, they had the absolute right to remain silent. The U.S. Constitution, that's our Fifth Amendment, the right to remain silent. They had a constitutional right to refrain from speaking and instead hire an attorney to speak for them. They were exercising the fundamental rights of the United States and the Florida Constitutions. Both constitutions permit retaining an attorney. That's what they're saying here. And that is, just so you know, the right to counsel is the Sixth Amendment of the U.S. Constitution. They talk about how Florida's Constitution is even broader. Sixth Amendment right to counsel is a recognized constitutional right. The right to hire and consult with an attorney is protected by the First Amendment, freedom of speech. So we have the First Amendment, freedom of speech, to talk or not talk. The Fifth Amendment, the right to remain silent. The Sixth Amendment, the right to retain counsel. And the Due Process Clause of the 14th Amendment of the U.S. Constitution. That is 4 constitutional rights that they are asserting that protects them from being sued for intentional infliction of emotional distress. Okay, I'll scroll through the rest of this so you can take a look at this. They cite the Florida Constitution. And then they get into the factors, the elements of intentional infliction. One of those is the plaintiff, there's case law, I guess in Florida is what this is saying, that you have to be present to have the infliction of the emotional distress. And because they heard about it, they were not present, okay? So that fails, is what they're claiming here. You can go ahead and read this. Read these paragraphs if you want. And we're getting to the end of this. There's no causation, right? They have to also show that they meet, that the Laundrie's actions caused the mental suffering, caused the emotional distress. And they're saying that, first of all, the outrageous conduct, first of all, they don't think that retaining counsel, exercising your constitutional rights amounts to outrageous conduct. But they're also saying that whatever conduct the Laundries engaged in did not cause the emotional distress. And it was not severe emotional distress that was suffered. That's what they're claiming. They're saying that the plaintiffs, the Petitos concede in their complaint that the Laundries did not cause the grief because they used the word, at least in part. The Laundries knew of the mental suffering and anguish of the plaintiffs and knew they could alleviate, at least in part. So it needs to be the sole and proximate. In other words, the actions of the Laundries has to be the sole and proximate cause of the plaintiff's distress. And they're saying, no, it wasn't. Since the alleviation could only come after the suffering has already been experienced. They were already suffering. They were already reaching out, begging, wondering where their daughter was. The Laundries' alleged failure to alleviate is not the sole or proximate or legal cause of the plaintiff's alleged injury. Go ahead and read this. And then finally here, the complaint does not allege or factually support that the emotional distress was severe. And that's one of the requirements. That's one of the elements of intentional infliction of emotional distress. Yeah, this is sad. They were extremely distraught, desperately seeking, but that does not specifically discuss how the plaintiff's suffering meets the severity element. Okay, I'll scroll through this. In sum, the plaintiffs had failed to satisfy the elements of causation, showing that what the Laundries did was the sole cause of the suffering of Gabby's parents, and that suffering was severe. They would have been upset about their daughter regardless of anything the Laundries could have said. And I get it, this is tough to read, but that fear or sadness was not caused by the Laundries. That's what the Laundries are claiming. In conclusion, the plaintiffs have not and cannot set forth a factual assertion that can be supported that gives rise to liability. Not legally sustainable. The lawsuit and the complaint should be dismissed with prejudice and without the opportunity to amend it. And that the defendants request the court to dismiss the complaint with prejudice. In the last page, respectfully submitted, this is their new counsel, P. Matthew Luca. Okay, he's the attorney representing Brian's parents. And this is also saying it was filed by the court and it was mailed to Patrick Riley, who is the attorney representing Gabby's parents. Okay, so that's a pretty, that motion to dismiss, the judge is going to make a decision. And again, the decision is based on the four corners. What is in the four corners of the complaint? They don't take testimony. The judge isn't going to listen to witnesses. They're not going to listen to any other evidence. There's not going to be any testimony if there's a motion to dismiss hearing. The court will make their decision based on what is in the four corners of that complaint. Did they allege the facts? Do the facts support those elements for intentional infliction of emotional stress? Do they have any defenses? Constitutionally, if any one of these constitutional arguments supports, then the court could say that they have the right to remain silent. They didn't have to do anything. They have the First Amendment right to remain silent, the Fifth Amendment right to remain silent, Sixth Amendment right to retain counsel, the 14th Amendment right of due process, right, of privacy. So, and even the court has to make a call here. Does that state what those words that were in that complaint? Does it state a cause of action? And could it ever state a cause of action if these constitutional rights are permissible and asserted, and the court finds that? So the court has two options. They can either dismiss it with an opportunity for them to amend to fix the pleading, or they can dismiss it with prejudice, and that's it. That's the end of this lawsuit. Okay, so procedurally, I have to look at my notes here. So the Gabby's parents are going to file a written response to this motion to dismiss, and now it'll be up to the court to decide whether the court will make a decision based on just the motion and the response to the motion, or whether the court will have a dismissal hearing to to address this, meaning both parties and their counsel would have a hearing with the judge, and the judge would, make a determination, ask questions, and figure out whether this motion to dismiss should be granted with or without prejudice. When they do that, when this motion and when the Gabby's parents have to reply to this motion to dismiss, I don't know, but I assume that the court's probably going to issue an order setting out when the deadline is for Gabby's parents to file a response to the motion to dismiss, and possibly set a date for a hearing, a dismissal hearing on this motion to dismiss. Okay, so, and what happens if there's a motion, if the motion to dismiss is granted? There's a possibility, I think, I know this is in California, but possibly, that Gabby's parents would have to pay the costs. Possibly, I don't know, the costs to Brian's parents, and the cost would probably be just, I don't think it relates to attorney's fees, but I think it relates to any costs that they incurred regarding this lawsuit and responding to it. And, do they have a right to appeal? So let's say the judge throws it out, grants a motion to dismiss. Do Gabby's parents have a right to appeal the judge's decision? Yes. But they're going to have to show abuse of discretion, I think. I mean, that's in California. Abuse of discretion to show that this judge did something, that was not normally done, abusing their discretion. Therefore, they have the right to have the motion to dismiss decision thrown out. I don't think that's likely. But you always have a right to appeal. And then the other thing is, I think it's more than likely, again, just my opinion, I think it's more than likely the court's going to have a hearing on the motion, a dismissal hearing, to give each side an opportunity, to address whatever issues they want. In other words, to argue what's in there, both the motion to dismiss by the Laundries and then the response to the motion to dismiss by Gabby's parents, and to give them an opportunity, and also for the court to ask questions. But again, the court's not going to be taking any testimony at that hearing. It's just related to what did they say in the complaint, in the four corners of the complaint, and was that sufficient? And assuming all of that's true, does that amount to intentional infliction of emotional distress? And what defenses do they have, right? So, thank you very much for watching. Please do leave a comment. I want to know what you think, because this is just my opinion. Please leave a comment or question. Please hit the like button. Also share these videos. And again, look at the previous videos I did, to get you up to speed on all of this. So please do subscribe. And again, thank you for subscribing and supporting my work. And thank you very much for watching.